Well, good afternoon again. This is Shirley Blakely. I'm pleased to introduce our next speaker, which will be Ms. Geraldine June, speaking on restaurant and vending machine labeling. This is the proposed rules, so I'm going to turn it over to Geraldine June.
Thank you, Shirley. This afternoon, I will discuss two proposed rules that FDA issued. The first is the proposed rule for the labeling of standard menu items sold in restaurants, and the second is the proposed rule for the labeling of food items sold from vending machines. First, I'd like to start you off with a quiz. The question is, does the health care reform legislation that was passed in 2010 include requirements for food labeling? Please answer yes or no. The full title of the law that mandates labeling of foods sold in restaurants and from vending machines is the Patient Protection and Affordable Care Act. We refer to it by the short title, the Affordable Care Act. Section 4205 of the Affordable Care Act amends certain nutrition labeling provisions of the Federal Food, Drug, and Cosmetic Act. In my presentation, I will refer to this act as Section 4205 or simply the law. Section 4205 requires covered establishments to provide certain nutrition information for standard menu items and calories for foods sold in vending machines. So now let's look at the results of the first quiz. Okay, it looks like 84% of those who answered said yes. And you're correct. The health care reform legislation did, as I just mentioned, include provisions for labeling of food sold in restaurants and for food sold from vending machines. So who does the law apply to? Section 4205 applies to restaurants and similar retail food establishments that are part of a chain with 20 or more locations, doing business under the same name, and offering for sale substantially the same menu items. The law also applies to a person engaged in the business of owning or operating 20 or more vending machines. Section 4205 requires covered restaurants and similar retail food establishments to disclose calories on menus and menu boards for standard menu items, post a statement concerning suggested daily caloric intake on menus and menu boards, disclose calories on signs adjacent to food on display and self-service food, provide additional written nutrition information in addition to calories to consumers upon request, and post on menus and menu boards a statement informing consumers that this written nutrition information is available upon request. Section 4205 also sets out requirements for operators of vending machines. It requires vending machine operators to provide calories for vended items unless the purchaser can examine the nutrition facts panel before purchasing, or if the purchaser has access to other visible nutrition information at the point of purchase. The law permits vending machine operators not covered by the law to voluntarily register with FDA to be covered by the labeling provisions of Section 4205. Section 4205 is specific about some of the requirements. In other cases, the law requires us to issue regulations to carry out some provisions. Specifically, the law requires FDA to establish a regulation to specify a succinct statement concerning suggested caloric intake designed to enable the public to understand the context of the calorie declarations. The law also requires FDA to establish by regulation standards for determining and disclosing the nutrient content for standard menu items in different flavors, varieties, and combination meals. Similar to the voluntary registration provided to vending machine operators, Section 4205 permits restaurants and similar retail food establishments not covered by the law to voluntarily register with FDA to be covered by the labeling provisions of the law. As some of you may know, there are several state and local jurisdictions, such as Maine, California, New York City, Philadelphia, Seattle, and Montgomery County, Maryland, and others that already had requirements for menu labeling in their jurisdictions. The federal law, however, preempts state and local laws that are not identical to the federal law for covered establishments. In other words, these state and local jurisdictions cannot have menu labeling requirements that are different from the federal requirements. The law also requires FDA to publish a proposed rule to implement the menu and vending machine provisions within 1 year of the law being passed. So now I would like to go through the proposed requirements for menu labeling, and later I will discuss the proposed requirements for vending machines. As you see here, we published our proposed rule on menu labeling in the Federal Register in April of last year. Here you see the Federal Register citation. These are the key components of the proposed rule. First, we proposed what establishments were covered. Next, we proposed what food was covered. We proposed definitions and requirements for menus and menu boards and for standard menu items. We also proposed requirements for calorie declarations, the succinct statement, and what must be included in the written nutrition information. So now I would like to invite you to take another quiz. The question is, on the effective date of the rule, of the final rule, will FDA require all restaurants to have calorie disclosures? Please answer yes or no. What establishments are covered by Section 4205? We propose that the covered establishments are those provided in the law, which are restaurants and similar retail food establishments that are a part of a chain with 20 or more locations, doing business under the same name, and offering for sale substantially the same menu items, as well as those restaurants and similar retail establishments that voluntarily register to be subject to the requirements. In other words, if you register, you must comply with the requirements. The law used the term restaurant and similar retail food establishment, but did not define it. So we propose that a restaurant or similar retail food establishment is a retail establishment that offers for sale restaurant or restaurant-type food to consumers, where the sale of food is the primary business activity of that establishment. Now, as you see, we have introduced some new terms which we had to define. We had to describe what we meant by primary business activity. We propose that a restaurant or similar retail food establishment has as its primary business activity the sale of food if it presents itself publicly as a restaurant, or more than 50% of the establishment's gross floor area is used for the preparation, service, consumption, or storage of foods. Okay, now let's take a look at the results of the last quiz. Seems that 87% said no, and that is correct. All restaurants would not have to have the required information. Using the definition I just described for a restaurant or similar retail food establishment, I would like to point out what establishments would likely be covered and which likely would not. Those covered are those establishments commonly understood by consumers to be restaurants, as well as multi-purpose establishments that present themselves as restaurants, such as entertainment venues that have restaurant food and also another activity such as games. Grocery stores and convenience stores that sell restaurant or restaurant-type food would also likely be covered. Those not covered under the proposal include entertainment venues such as movie theaters and amusement parks, as well as general merchandise stores, hotels, and transportation vehicles. In the preamble of the proposed rule, we offered an alternative to the definition of restaurant and similar retail food establishment. Using this alternative, we stated that a restaurant or similar retail food establishment is a retail establishment that offers for sale restaurant or restaurant-type food, where the sale of restaurant or restaurant-type food, as opposed to food in general, is the primary business activity of that establishment. With this alternative, we stated that a restaurant or similar retail food establishment has as its primary business activity the sale of restaurant or restaurant-type food if it presents itself publicly as a restaurant, or more than 50% of the establishment's gross floor area is used for the preparation, service, consumption, or storage of restaurant or restaurant-type food. Now, under this alternative definition, many grocery and convenience stores would not likely be covered because they may not present themselves as restaurants, or they may not devote more than half of their gross floor area to restaurant or restaurant-type food. So you have been hearing me use the term restaurant food and restaurant-type food. Now I will describe what those terms mean. We propose that the term restaurant food means food that is served in restaurants or other establishments in which food is served for immediate human consumption, and that is to be consumed either on the premises where the food is purchased or while walking away, or which is sold for sale or use in such establishment. We propose that the term restaurant-type food means food of the type described in the definition of restaurant food that is ready for human consumption, offered for sale to consumers, but not for immediate consumption. It's processed and prepared primarily in a retail establishment and not offered for sale outside of that establishment. So this would include food that's ready to eat but not eaten on the premises, such as takeout food. Now, what is meant by the term menu or menu board? The law defines this term as the primary writing from which a consumer makes an order selection. In other words, what do you use to choose the food you want to order? In the preamble of the proposed rule, we stated that there are different types of menus, such as breakfast, lunch, dinner, dessert, beverage, and children's menus, as well as electronic menus. We all know that you may order food from your computer, so we consider a menu on the Internet to be a menu subject to the menu labeling requirements. We recognize that in any given circumstance, a consumer may be able to order from many different menus, even from the same establishment. Given the importance for all consumers to have access to nutrition information, when making order selections, FDA proposed that primary writing should be interpreted from a consumer's vantage point. So FDA tentatively concluded that menu or menu board includes any writing of the covered establishment that is the primary writing from which a consumer makes an order selection. As I previously mentioned, the menu labeling requirements apply to standard menu items. So what are standard menu items? FDA proposed that the term means a restaurant or restaurant-type food that is routinely included on a menu or menu board, or that is routinely offered as a self-service food or food on display. Standard menu items include combination meals and variable menu items. Okay, let's try another quiz. Please indicate if the following statement is true or false. When the proposed rule is finalized, all foods sold in covered restaurants will have to have calorie declarations. Is this true or false? Section 4205 exempts certain foods from the menu labeling requirements. These foods are condiments placed on the table or counter for general use, custom orders, daily specials, temporary menu items appearing on the menu for fewer than 60 calendar days per year, and foods that are part of a customary market test appearing on the menu for fewer than 90 days. We propose that these foods not be covered. Okay, let's look at the results. And I guess I should have mentioned that for my quizzes, I put them before I gave you the information just to see what you thought would be covered by these requirements. So 79% of you said that it is false that all foods will have calorie declarations. And, of course, that's right, because, as I mentioned, certain foods were exempted by Congress from declaring calories. What about alcohol beverages? In the proposed rule, we stated that it was unclear whether Section 4205 was intended to cover alcohol beverages. Therefore, FDA proposed that they not be covered by the menu labeling requirements, but we requested comment on whether they should be. How should the calories be displayed for variable menu items? As I mentioned before, the law requires that we establish by regulation standards for determining and disclosing the nutrient content for standard menu items that come in different flavors and varieties, and combination meals. We started by proposing a definition for variable menu items. We proposed that a variable menu item means a standard menu item that comes in different flavors, varieties, or combinations, and is listed as a single menu item. An example of a variable menu item could be a soft drink in different flavors, or a combination meal such as a burger with a choice of fries or side salad and a choice of beverage. We propose that the calories for a variable menu item be declared as a range from the lowest possible value to the highest possible value. For example, you could have a range such as 150 to 200 calories. In the preamble to the proposed rule, we did discuss some alternatives of using a range, such as using an average or using combinations of averages and ranges, depending on the range of the calorie content. Section 4205 requires nutrition information for self-service food and food on display, such as food sold at a salad bar, a buffet, or cafeteria line, and self-service beverages. We propose that some of these foods, we recognize that some of these foods already have food tags or signs that list the name, price, or both. For these foods, we propose that if a food has a sign near it with the name of the food, price, or both, calories per displayed food item or per serving must be declared on that sign. If there is no sign for these foods, FDA proposed that the establishment must place a sign next to the food with the calories per item or per serving. As directed by Section 4205, FDA proposed that the following statement must appear on menus and menu boards in covered establishments. Now, this is the so-called succinct statement regarding daily caloric intake. We propose the statement, a 2,000-calorie daily diet is used as the basis for general nutrition advice. However, individual calorie needs may vary. As required by the law, FDA proposed requirements for the written nutrition information that must be made available to consumers upon request. First, we propose the following statement of availability, and it reads, additional nutrition information available upon request. FDA also proposed that the nutrition information that you see listed on this slide must be available in the written nutrition information. Now, if you are familiar with the nutrition facts label, you see that these are the same nutrients that are listed on the nutrition facts label, with the exception of the vitamins and minerals, which were not required by the law to be made available in restaurants. So that's an overview of our proposed rule on menu labeling, and the comment period closed on July 5th, 2011. We propose that the final rule become effective 6 months from the publication of the final rule. We also requested comments on that effective date. We received approximately 900 comments by the end of the comment period. The comments generally supported menu labeling. Some comments gave suggestions for changes to the proposed requirements. Some controversial issues discussed in comments were the scope of covered establishments. There were comments for and against the inclusion of entertainment venues such as movie theaters, and for and against the inclusion of grocery and convenience stores. We received many comments on whether alcohol beverages should be covered by the requirements. We have evaluated the comments and will continue to make decisions on what provisions we will finalize as we develop the final rule. Now I would like to turn to vending machines and to discuss our proposed rule on vending machine labeling. The proposed rule for vending machine labeling published in the same issue of the Federal Register as the menu labeling proposed rule. In this proposed rule, we proposed definitions, we identified who must comply, and we proposed how the calories must be disclosed. So who must comply with these requirements? The law requires, and we propose, that vending machine operators who are engaged in the business of owning or operating 20 or more vending machines that dispense food and the vending machine does not permit a prospective purchaser to examine the nutrition facts panel prior to purchase or does not otherwise provide visible nutrition information at the point of purchase must comply with the requirements. Who is not required to comply? The law provides, and we propose, that vending machine operators who operate fewer than 20 vending machines that dispense articles of food do not have to comply with the requirements. We propose that vending machines that may dispense food as part of a game or other non-food related activity do not have to provide calorie information. We also propose that bulk vending machines that do not have a selection button and may dispense a single type of food, such as gumballs, do not have to provide calorie information. We propose that the statement of the number of calories must be expressed to the nearest 5-calorie increment up and including 50 calories and 10-calorie increment above 50 calories. And this is the same as we have for packaged foods. We propose that the terms calories or the abbreviation CAL must appear adjacent to the number of calories. We propose that the calories may be placed on a sign in close proximity to the article of food or its selection button. And in order to ensure that consumers can obtain the calorie information, we propose that if the sign is adjacent to the vending machine, the sign must be visible at the same time as the food, its name, price, or selection button or number. As I mentioned before, a vending machine operator is not required to provide calories if the nutrition facts panel can be examined prior to purchase. In order for the nutrition facts panel to be visible, we propose that it be fully visible without any obstructions and be in a type size that is easy to read while the food is in the machine. A vending machine operator is also not required to provide calories if the vending machine provides visible nutrition information at point of purchase. So the comment period closed on the same date as that of the menu labeling. We received approximately 250 comments, and some issues brought up were whether bulk vending machines should be covered, the use of signs to post the calories, and what should be the effective date of the rules. As with the menu labeling proposal, we have been evaluating the comments and developing our final rules. And at this time, I cannot predict a time when the menu and vending machine labeling rules will be final. So with that, I close, and I thank you for your attention today, and we'll see if we have any questions.
Thank you very much. We definitely have quite a few questions, and I'm going to take them in the order that they were posted. We will try to get to as many as possible today. The first one is, can you please address deli and ready-to-eat foods in retail stores, more than 20 stores, for example, and how the law impacts the reporting? How the law impacts reporting.
Okay.
Deli and ready-to-eat foods?
Oh.
And menu labeling?
Okay. If we have an establishment that meets the requirement or the definition, of a restaurant or similar retail food establishment, that establishment would have to provide calories for foods that are standard menu items in those establishments.
Okay, the next question is, does the vending machine information relate to those in schools as well as that covered in a different place? Is that covered in a different place in the law, I guess?
Oh, the statute requires calorie disclosures on vending machines where the operators have 20 or more, and it does not stipulate where these vending machines are located. So they would be vending machines that could be anywhere.
I think we're pretty much out of time. We need to move on, and thank you so much for answering the question, and thank you, the audience, for sending in some very interesting questions. We're going to move to our next presentation.